Car accident claims and witnesses. If you are involved in a car accident, you should try to get a witness's details. More specifically, you should ask for their name, address, and their telephone number. The witness does not need to have just seen what happened to you, they could have seen how the other driver behaves before or after the accident. The importance of witnesses. Witnesses are considered very important in a personal injury case as they are often seen as being quite neutral. Plaintiffs and defendants, however, can seem quite biased to a jury simply because it's in their interest to get their side of the story across. Witnesses, however, have no reason to exaggerate what they saw, and they have no stake in the case's final outcome. This is why a jury and a judge is likely to believe what a witness has to say. Witnesses can have a false perception of what happened while the accident was taking place, but this can happen to anyone. However, as they tend to be unbiased, they can often see who was at fault for the accident. Juries will, therefore, frequently look to the witnesses to give them the most realistic and credible explanation as to what happened. Using a witness during the claims process. If you managed to get the names, addresses, and telephone numbers of any witnesses, you should give the details to your lawyer. Your lawyer can contact the witnesses and try to determine what they saw and what they remember. In some circumstances, witnesses may not remember anything, they just happen to be in the area at the time. If this occurs, your lawyer will have no use for that witness. If a witness does remember what happened, their testimony may be of use to you. In this case, the lawyer will take a recorded statement from the witness. They do this so that the witness's statement locks them into the position. While a recorded statement is never given under oath, it means it has limited use in a car accident trial. However, it can also be used to determine how credible the witness is if their statement changes between the date the statement was taken and the trial. Differences between your statement and the witness's. There may be occasions when the witness's version of how the accident took place differs from yours. If this should happen, your lawyer may have a few difficulties. This is because the lawyer would like to believe your side of the story as you are their client. However, if the lawyer is given credible evidence that your side of the story may not actually be what happened, they may need to investigate further. If your lawyer decides that your side of the story is not what happened, they may need to review the evidence with you. Your lawyer can then recommend how far the case can go based entirely on the evidence they have. If it looks as though the evidence is not weighing in your favor, then your lawyer may suggest that you settle the case. If your lawyer decides that your side of the story holds a lot more weight than the witness's side of the story, your case will continue and the witness may be cross-examined should the case go to trial. Will the insurance company read the witness's statement? It is highly unlikely that your lawyer will show the witness's statement to your insurance company. Once the lawsuit has been filed, however, the statement may be seen by the defense attorney. However, this all depends on which state the lawsuit is filed in. Can I read the statement before the trial? Most lawyers won't let you see the witness's statement before the deposition has taken place. However, if you do read the witness statement before you go to try, it may well mean that the defense attorney is entitled to a copy too. This is the case even if the court would ordinarily rule that they cannot see the statement. This is why your lawyer may not show you the statement until the trial is about to take place. They are merely trying to keep the statement out of the defense attorney's hands.